Case law supporting foreign asset protection trusts. There is a lot of misinformation on foreign asset protection trusts, FAPTs. Movies portraying criminals utilizing offshore banking and offshore trusts for fraudulent purposes can promote a false impression. Mobsters and drug cartels sometimes use offshore trusts. Criminals also drive cars, buy homes, and dine out at restaurants. This does not make these activities unethical or illegal, any more than criminals using trusts makes trusts unethical or illegal. This is attorney Jim DeLoisio, Director of Legal Services for Torchlight Tax. A trust is simply an agreement between a truster, the person who creates and puts assets into the trust, a trustee, who manages the trust, and beneficiaries. The fact is, FAPTs, aka Foreign Asset Protection Trusts, are simply trusts in foreign jurisdictions. They are hated by creditors and civil litigation attorneys because they are extremely effective at preventing a creditor or winning plaintiff from seizing assets that have been transferred into the trust. The fact that an attorney wins a large U.S. judgment against a truster does not mean they will collect on the judgment. These trusts are effective because they are operating in jurisdictions that have created trust laws designed to protect the truster's assets in the trust as a way of increasing trust business in their country. Not being in the U.S., they are not under the jurisdiction of U.S. courts. They need not comply with U.S. court orders. 17 states in the United States now offer domestic asset protection trusts, DAPTs. The trust legislation in these states was modeled after the Cook Islands Trust Law. DAPTs, however, are not as effective as FAPTs because they are subject to U.S. court orders. Other countries have also modeled trust legislation after Cook Islands law. There are differences, however. The best of these are also more effective than DAPTs because they are not under the jurisdiction of U.S. courts and can reject U.S. court orders. In these jurisdictions, creditors and attorneys with a U.S. judgment must go to the country the trust is established in to sue there under their law. These laws are much more favorable to the truster, aka grantor or settler. One would badly assume these laws are some sort of scam or artifice. They are just different and generally traced back to British common law. The attorneys and trust companies of trust haven countries are part of the international community every bit as much as U.S. attorneys and trust companies. Evolution of foreign asset protection trusts. The evolution of the trust originated in ancient Roman and Greek law and was later refined in 12th century England into the modern trust we recognize today. The offshore trust was introduced during the 20th century. The Cook Islands was the first to successfully amend its international trust law to include several provisions that were unfavorable to creditors and specifically to allow for self-settled spendthrift trusts. A self-settled spendthrift trust is a trust designed to protect trust assets by having the trust hold the assets for the benefit of the beneficiaries, and also allow the person who sets up the trust to be a beneficiary. Cook Islands law allows the person who founded the trust, called the truster, grantor, or settler, to maintain significant control of the trust assets by being the manager of a Cook Islands LLC under the trust. The Cook Islands legislation was soon followed by similar laws in the Cayman Islands, Belize, Nevis, the Channel Islands, the Isle of Man, and numerous other trust haven jurisdictions. The U.S. adopted domestic asset protection trusts in some states starting in 1997. Alaska passed the first U.S. legislation allowing for irrevocable discretionary self-settled trusts. 90 days later, Delaware followed suit, and as of this date, several states have passed Domestic Asset Protection Trust (DAPT) legislation adopted from the Cook Islands Trust legislation. A very popular method to protect one's hard-earned or inherited assets is through the establishment of an irrevocable discretionary trust in a debtor-friendly foreign jurisdiction such as the Bahamas, Belize, Nevis, St. Vincent, or the Cook Islands. Over time, offshore asset protection trusts have proven to be a fortress against U.S. judgments. FAPTs versus DAPTs. The general idea is that FAPTs are stronger than DAPTs because they have the ability to ignore foreign court orders. A lot of plaintiffs' attorneys in matters involving offshore trusts do not like FAPTs because they make it extremely difficult for them to collect money from the offshore trusts. Also, U.S. attorneys may prefer DAPTs over FAPTs, as DAPTs do not require U.S. attorneys to find attorneys in these trust havens to create FAPTs in compliance with legislation in these havens. Case law on FAPTs in the Cook Islands. Belize, St. Vincent, or Nevis is relatively scarce, mainly because a very limited number of trusts are attacked or taken to trial. In addition, the fact that FAPTs are private in nature makes it difficult for foreign judgments to thrive against them. Trust deeds in Belize, Cook Islands, and other jurisdictions are not accessible to members of the public. FAPTs are extremely difficult to penetrate, while DAPTs are exposed to U.S. judgments. Through the drafting of a trust deed, FAPTs are structured in such a way that the truster can control assets of the trust through an LLC linked to the trust until a time when the truster is being sued. When a lawsuit is enacted against the truster, provisions of the trust deed instrument will automatically kick in to make another person other than the truster responsible for managing assets. If a foreign, for example, U.S. court, directs a trustee to transfer assets, the trustee will refuse the direction as a violation of the law of his jurisdiction and the trust deed. Lack of jurisdiction makes the transfer of assets back to the U.S. nearly impossible. Enforcement of a foreign judgment on FAPTs is therefore extremely difficult. Even if the court orders the truster to order the trustee to transfer the funds, the trustee will refuse. The following is a discussion of case law on U.S. judgments against FAPTs in various jurisdictions and how they fail to execute said judgments on said FAPTs, showing the formidability of FAPTs against foreign creditors. Case law analysis. Brown versus Higashi. The defendants, S. Wayne Brown, a certified public accountant and successful businessman, and his wife, Carol, created a series of self-settled trusts. One of these trusts, the CAW Family Trust, was formed in the United States and governed by American law. The defendants acted as trustees of this trust and admitted that its assets were part of their bankruptcy estate. Two other trusts were created during this same period, named the Leones Company and American International Retail. Each of these trust deeds expressly stated that they were executed in the country of Belize and were to be interpreted and construed under Belizean law, formerly known as British Honduras law. Each trust document provided for the establishment of an irrevocable trust controlled by a trustee with the authority to make discretionary distributions of trust property. The defendant, S. Wayne Brown, signed the trust documents through an attorney-in-fact in Belize, one Gregory MacDonald, who acted as the creator of the trusts. A trust certificate for 100 units was executed in favor of Mr. Brown for each trust. Trust certificates are akin to stock shares. Mr. Brown, through his attorney-in-fact, immediately amended the trust certificates so that 50 units were issued in his favor and 50 in favor of his wife in each trust. Upon the formation of the Leones Company, the defendants, S. Wayne and Carol A. Brown, became the president and secretary of the trust, respectively. The defendants filed for Chapter 11 relief on March 31, 1995, after the plaintiff had obtained a judgment against them and their business corporation, Nome Commercial Company, for approximately $1.4 million. They submitted a joint Chapter 11 plan for themselves and Nome Commercial Company, which initially went to a confirmation hearing on January 23, 1996. The confirmation hearing has continued. pending the resolution of this proceeding. In its judgment, the court held that the policies underlying Belizean law conflicted with the fundamentals of American fraudulent transfer law. Belize is a popular trust jurisdiction specifically because it permits types of transfers considered fraudulent and unenforceable in the United States. The court described Belize as a jurisdiction notorious for anti-creditor policies and highlighted that the absence of fraudulent transfer precepts in Belize makes it a favorable location for asset protection. Foreign Asset Protection Trusts, FAPTs, are so robust that even where a trust deed is poorly drafted, the FAPT can still shield assets from U.S. court orders due to strong legal safeguards provided by FAPT legislation in certain jurisdictions. Contempt of court arises not from establishing a trust, but from disobeying a court order, something no attorney would recommend. This concept is further examined in the case of FTC versus Affordable Media, LLC. FTC versus Affordable Media, LLC. The case involves Denise and Michael Anderson, who, through Financial Growth Consultants, LLC, ran a telemarketing scheme promoting media investments with promises of a 50% return, which turned out to be a Ponzi scheme. They funneled their commissions into a Cook Islands trust, claiming it was beyond U.S. court jurisdiction. When the FTC sued them for fraud, the Andersons argued they couldn't repatriate the trust assets due to its structure and Cook Islands law. The key issue was whether the Andersons could be found in contempt for not obeying a court order to repatriate assets in a foreign trust, which the FTC aimed to recover for defrauded investors. The FTC won the underlying Ninth Circuit appeal against Affordable Media, LLC, and sought to recover the Andersons' assets. Typically, with a well-structured Cook Islands Asset Protection Trust, APT, U.S. courts would have little ability to access those assets. But since the Andersons were trustees, this created a possible recovery route. However, despite their poorly structured APT, the Andersons used a duress provision to block recovery. This provision removes the Andersons as co-trustees if an event of duress occurs, helping them avoid U.S. court efforts to seize the assets. Due to a temporary restraining order from the U.S. court's preliminary injunction, the duress provision in their trust was activated, resulting in their removal as trustees. The U.S. courts then sought to repatriate the assets from the foreign trust, leading to the Andersons being held in contempt and jailed until they complied. They were eventually released after agreeing to instruct the trust to remove the overseas trustee and replace it with FTC Inc., a corporation formed by the FTC. Appoint FTC Inc. as the new protector of the trust and amend the trust to remove the FTC as an excluded person. The Cook Islands Court ruled that the documents intending to remove the current Cook Islands trustee and appoint the FTC were an invalid use of the protector's powers. The attempted amendment would be invalid, as it would benefit an excluded person. And the appointment of the FTC as protector was also invalid for the same reason. Costs were awarded against the FTC in favor of the Cook Islands trustee. The FTC ultimately decided to waive its appeal rights in the Cook Islands and settled with the Cook Islands trustee, releasing the trustee and the trust from further liability. This case illustrates the far-reaching statutory protections of the Act, capable of protecting assets in an asset protection trust, APT, even one as poorly structured as the Andersons' APT, and in situations involving clear evidence of egregious criminal conduct. It also highlights that U.S. courts do not have jurisdiction over foreign asset protection trusts, FAPTs, and trustees in foreign jurisdictions can refuse to return assets successfully. Branch Banking and Trust Company versus Hamilton Greens, LLC. BB&T filed a breach of contract claim on May 5, 2011, against multiple parties, including Bellinger. On November 17, 2011, Bellinger began the process of creating a Cook Islands Trust. According to Bellinger, the BB&T claim did not influence his decision to establish the trust because the property securing the $3 million loan from BB&T was valued at $15 million. His co-guarantors had a combined net worth of over $100 million. They had agreed to indemnify him for any liability related to the BB&T claim, and they had settled all of his other contingent liabilities from similar personal guarantees in the previous 5 years. Although Bellinger was not held in contempt for failing to repatriate the trust funds, BB&T held a valid and unsatisfied writ of execution and met the requirements to begin supplementary proceedings. In assessing whether Bellinger intended to defraud BB&T, the court determined that his primary motive was to preserve assets for retirement. The court also considered that Bellinger might have been under the mistaken belief that the collateral used for the BB&T loan was sufficient to cover his debts. Throughout the litigation, Bellinger consistently testified that he could not compel payment from the trust, as the Cook Islands trustee had refused, and he lacked the ability to remove the trustee. Between March 2012 and May 2013, Bellinger received monthly distributions from the Cook Islands APT for overhead costs of support, which were later reclassified as payments to his girlfriend. Unlike a domestic trust, Bellinger was able to continue benefiting from his trust throughout the process, protected by the provisions of the Act. Even if the U.S. court had ruled the transfers fraudulent, the Cook Islands trustee would not have been required to comply with the U.S. court's order or return the assets. FAPTs in the Cook Islands, which has legislation for fraudulent transfers, require that alleged fraudulent transfers be proven in the Cook Islands courts, even if the U.S. has already found the transfer in question fraudulent. A U.S. court ruling of fraudulent transfer does not obligate a Cook Islands trustee to comply. In Re. Smith, the case involves an involuntary bankruptcy proceeding against Smith. On March 27, 2008, the state court issued a severance order to enter a final judgment against Smith. However, just 3 days prior, Smith had established a Cook Islands trust and transferred assets worth approximately $6 million into the trust without receiving any consideration in return. On the night before the hearing regarding the creditor's post-judgment turnover application in state court, Smith submitted a pauper's affidavit, asserting that his net worth was negative $2,041,486.24, and that he only had 2 creditors. The bankruptcy court noted that while Smith was keeping up with small recurring payments, he was failing to pay 99% of his debts. This was largely due to his decision to transfer most of his assets into a Cook Islands trust. In involuntary bankruptcy proceedings, typically, more than 3 creditors are needed, but the special circumstances exception applies when a person takes steps to undermine creditors' rights. Here, Smith's transfer of assets into the trust and the addition of a spendthrift provision to prevent creditors from accessing those assets indicate that the special circumstances exception is relevant. The order for relief was issued under U.S. bankruptcy law. However, a properly structured Cook Islands trust was not obligated to transfer Smith's assets to creditors, and enforcing this transfer would have required establishing the fraudulent nature of the transaction in the Cook Islands court system. Rush University Medical Center versus Sessions. Robert Sessions established an irrevocable inter vivos trust, transferring most of his assets into it and designating himself as a lifetime beneficiary. The trust allowed the trustees to distribute assets and income to Sessions for his support during his life, gave him authority over trustee selection and inheritance decisions, and included a spendthrift clause preventing the trust assets from being used to pay off creditors. After creating the trust, Sessions pledged $1.5 million to Rush University Medical Center, plaintiff, to fund construction for the university's president's residence. Despite the hospital's fulfillment of this project, Sessions never paid the pledge and later revoked it. When Sessions passed away, the hospital sought recovery of the amount from his estate. The trial court ruled that the spendthrift clause was invalid with respect to Sessions' creditors and ordered the trust to pay the hospital. The plaintiff's claim relied on the common law principle that an individual cannot create a trust for their own benefit while shielding those assets from creditors. The Illinois Supreme Court ruled in favor of Rush University Medical Center, concluding that Sessions' obligation to pay was valid despite the spendthrift clause. Rybolovlev versus Rybolovlev. The highly contentious divorce between Elena and Dmitry Rybolovlev led to a Swiss court ruling that Russian oligarch Dmitry Rybolovlev must surrender half of his nearly $8 billion fortune to his ex-wife, Elena. However, Dmitry's assets were securely protected within a Cook Islands trust, prompting the Geneva Court of Appeals to overturn the ruling. As a result, Elena had to pursue alternative recovery methods for a much smaller amount. Pursglove versus Osterland. Cook Islands trusts provide substantial asset protection, but transfers made under suspicious circumstances, such as in anticipation of a claim, can be challenged. Conversely, in such cases, the protection offered by Cook Islands statutes makes it difficult and costly to pursue a claim successfully. Sarah Pursglove and Robert Osterland instituted divorce proceedings against each other. After discovering her husband's extramarital affair, Pursglove went to extreme lengths to secure as much as possible from him. She sought access to Osterland's LLC, held in his Cook Islands Trust. Since the Cook Islands does not recognize foreign judgments, Pursglove traveled to the Cook Islands to sue in its courts for fraudulent conveyance, where she succeeded on the merits. The court determined that Osterland had transferred $45 million in assets to the Cook Islands Trust on the day his wife caught him having an affair. This transfer was deemed fraudulent, prompting Osterland to settle with his ex-wife. Had Osterland transferred the assets in a manner that did not constitute a fraudulent transfer, Pursglove would have had no viable claim. However, it required a deeply spurned Pursglove and significant financial investment to uncover this fraudulent transfer and enable her recovery. Deductions. If a trust is properly formed under relevant legislation, Belize, Cook Islands, or Nevis, funded with non-domestic assets, and created without circumstances deemed a fraudulent transfer, the assets in the trust are generally protected from attachment, both in the host country and in other jurisdictions. Typically, jurisdictions such as the Cook Islands, Belize, and Nevis will not recognize judgments from other jurisdictions, as this would undermine the judicial legitimacy of the countries against which U.S. judgments are made. Therefore, any challenges to foreign asset protection trusts, FAPTs, must be pursued in the jurisdictions where the trusts are established. Due to the robust protections afforded by the legislation in these FAPT havens, along with the inherent difficulties in recovering assets, many claims are never brought against FAPTs or are settled for significantly lower amounts. Additionally, the lack of public records regarding trustors in these jurisdictions indicates that U.S. creditors often struggle to successfully claim against FAPTs. The Anderson and Bellinger cases illustrate that even when orders are issued in a foreign jurisdiction, a properly constructed Asset Protection Trust, APT, will enable trustees to manage assets effectively, despite threats of contempt or other U.S. court orders. The scarcity of case law demonstrates the deterrent effect of these laws and highlights how few creditors are willing to challenge the act, especially given that those who do typically face unsuccessful outcomes. If you would like more information on setting up a foreign asset protection trust, contact Torchlight Tax for a free consultation at 877-758-7797 or email us at info@torchlighttax.com. If you like this video, please like it, share it, and subscribe to our channel so you can be notified when we release new videos. Thanks for watching. If you would like to see the actual court transcripts on which this analysis was based, please click the link in the YouTube description below.